Welcome to video presentation number 2 for Criminal Law with Professor Jack Guttenberg. Today we're going to talk about two concepts that are the central focus of modern criminal law. One of them is the concept of Actus Reus. The second one is, and is associated with Actus Reus, is the concept of voluntariness. At common law, Actus Reus involved two different concepts. One involved conduct, here shown by the runner. The other one involved results, shown here by the casket with the deceased. The result being death in this instance. Often the crime of murder is referred to as a result crime. Okay, let's go back and look at a couple of the offenses we looked at last time, or one offense we looked at last time, larceny, and we'll introduce a new one, burglary. So we talked last time that larceny was the taking and carrying away of the personal property of another. Okay, so now we want to ask, what is the actus reus of this offense? Meaning, what is the conduct here? So let's go back and do what we did with larceny before. We break it down into its elements: the taking, the carrying away, the personal property of another. Now we ask, what is the conduct? That is, what is the actus reus of this offense? Now when we talk about actus reus and we're talking about conduct, we're really talking about verbs. What in this offense are verbs? So let's take a look. And what we come up with are two different sets of elements that are verb elements, which means they are conduct. They are taking and carrying away. Taking is simply grasping hold of an object. Carrying away is the movement of that object, or sometimes referred to in the law as asportation. Now let's look at another offense, burglary, the breaking and entering of the dwelling house of another in the nighttime. This is a common law offense. What is the actus reus, and again, what is the conduct of this offense? Well, let's go back and do what we did before by breaking burglary down into its elements. Here we have breaking, we have entering the dwelling house of another in the nighttime. So here, what is the conduct? What are the verbs that apply in this offense? So let's ask our question. What is the actus reus? What is the conduct of this offense? And we quickly see that the conduct in this offense is the breaking and the entering. The breaking merely meaning the movement of a entryway door, the movement of a window, breaking open of a window, pushing open the door, and the entering simply, as we would know it, the insertion into the dwelling house of any bodily part, whether it's an arm, whether it's a finger, whether it's walking into the house, sticking a baseball bat into the house. All of that will be the conduct of entering. Okay, in both of these offenses you notice that there were other elements that appeared beyond the actus reus element of conduct, the taking and carrying away for larceny here, and the breaking and entering for burglary here. We see there are other elements: the personal property of another for larceny, the dwelling house of another in the nighttime here. These elements, which are merely fact elements that have to be proven, are given a different name. They are referred to as attendant circumstances. That is, they are facts that have to be proven. For larceny, it has to be something that is classified as personal property, and it has to be the personal property of another. A defendant cannot steal or commit larceny with their own property. Likewise, for breaking and entering, it has to be the dwelling house. That has to be whatever is going to be classified by law as a dwelling house. It has to be of another, and at common law, this offense had to occur in the nighttime. In each of these instances, These are facts that would have to be proved by a prosecutor. The prosecutor would have to prove that it's the personal property, that property was of another. They would have to prove whatever we would consider a dwelling house, whether that could be a home as we know it, a mobile home, an outbuilding on a dwelling house, and it had to be the dwelling of another, and it had to occur in what the law would consider to be the nighttime. All of these types of elements, these fact elements that need to be proved, are labeled attendant circumstances. They have to be proved just the same as the taking and carrying away or the breaking and entering. Now, let's go on and talk about another concept. As we said earlier, the Actus Reus was one of the pieces of the Actus Reus was conduct. Okay, so what does that conduct have to be? We're going to see through several cases and some other materials that the conduct has to be voluntary. Okay, the conduct being voluntary is critical to being for the prosecution to convict the defendant. What is voluntary? Well, several courts have referred to it as a willed movement. Now, we're going to spend some time talking about how a willed movement is going to be different than the mental state that's going to be required for each crime. But at the common law and in today's legal regime in the United States and throughout the common law world, all conduct, as it's referred to, must be voluntary. Let's talk about some of the things that aren't voluntary. It's easier to then see what might be voluntary. Okay, so what isn't voluntary? Spasms are not considered voluntary. Sleepwalking is not considered voluntary. Seizures are not considered voluntary. Conduct that occurs while a defendant is fainting would not be voluntary. In each of these instances, if the defendant's criminal conduct occurred during a spasm, during sleepwalking, during a seizure, or during fainting, that conduct would not be considered voluntary conduct and would not be sufficient to convict a defendant of the criminal offense. So let's take a look for a minute. So we know that conduct has to be voluntary. That means that in this instance, for larceny, the taking has to be voluntary. The carrying away has to be voluntary. For burglary, the breaking has to be voluntary, and the entering has to be voluntary. So let's ask, what would happen if the defendant took their neighbor's lawnmower, took possession of their neighbor's lawnmower, grasped a hold of it while they were sleepwalking? Well, that wouldn't be voluntary. It would not meet the element of taking and would not be sufficient to convict that defendant of larceny. So let's say during that same sleepwalking episode, they take the lawnmower and now they move it over to their yard. They are sleepwalking. All the evidence shows that, and the prosecution cannot rebut that. Again, that would not be considered voluntary conduct. The defendant could not be guilty. So let's say a different defendant, again, walking up to their neighbor's house now, thinking that they're going to do some nefarious things in that house, all of a sudden faint up against the front door and push that door open. They have fainted now. They've passed out. They bump up against the door and the door falls open. Now, that breaking by that defendant, again, would not be voluntary conduct. Finally, let's say as they bump up against the door while they're fainting, they now fall into the house. So now they faint, falling into that house. Again, that entering would not be voluntary. It would not be sufficient in order for a prosecutor to prove that they entered voluntarily. In each of these instances, the defendant's conduct must be proven to be voluntary. In most cases, the issue of voluntariness never comes up. Most people's conduct is assumed to be voluntary. However, in those instances where the defendant faints, can prove they were sleepwalking, There is evidence of seizures. There is evidence of, again, as I said, fainting spells, spasms. Those will all raise an issue of voluntariness that you must be aware of. This now concludes video presentation number 2.